with another exciting video. Now, in this video, Judge Simpson had to put this guy in his place, right? What happens? He's a career criminal, a defiant career criminal, and basically he's upset with his lawyer because his case is not going the way he wanted to go. He's telling his lawyer, per Constitution, we should get a speedy trial, right? But per freedom, if you don't do the crime, you don't do the time. Now, are there people in jail that's innocent? Yes, they are. But this guy has a bad temper, and he just think because he can scream at his lawyer, he can get things percolating. It don't work that way, right? Like Judge Simpson told him, stop making dumb mistakes, and then you won't be there. But what he do? Keep making these mistakes. But nonetheless, let's dive into the content. I don't want to ramble too much. I want you to definitely get this content, and then we'll catch you in the end.
We've been here previously. I thought we were coming for preliminary examination and relayed that to my client. He has discovery, but in the meantime, he got a second case on the same complainant. That has caused this to be converted, in my opinion, to be
a second case
on the same, calling from the jail. Allegedly, everything's allegedly.
Oh, the
calling
witness,
from the jail.
right? Okay, he picked up
everything's alleged.
Right.
So that caused a second case, and in my opinion, a second PCC. So we want a preliminary examination for everything. The people have advised me that they will go forward with or without the witness. I explained all this to my client. He exploded. So
what?
Exploded. Well, so I didn't know what I was doing.
Okay.
So, and not fighting for him. And that bothers me more. They can tell me I don't know what I'm doing. That annoys me. But when they say I'm not fighting for them, that goes to my core, since I come from a fighting family and I fight for everybody.
Oh, you do.
No, that just is making me talk to you. I am going to fight, but I got to fight within the rules. And I feel I know them a little bit better.
Counsel, I'm just trying to figure out, he told you weren't fighting for him?
Oh, for sure. And a lot more too.
Okay.
Yes, that's why I want to just express myself.
No, yeah, that's fine. You know, it's kind of funny to me when defendants that they're in custody, they find themselves in more trouble because you were trying to set this. You were fighting for them. You were fighting at me a little bit with this thing, and then has the nerve to say to you, "You're not fighting for them." When the reality is, at least allegedly, he's doing the stupid thing that's making your job harder. So that's fine. That's the way he wants to look at it. And the other thing is, and it just amazes me with some defendants, they come up here, they complain about their attorney, and they don't even realize the jewel that they may have representing them, and also don't realize, that fight is... It wasn't quite anything you did. It's just in your blood.
Thank you.
It is your heritage.
I was carrying.
He doesn't understand that. He doesn't understand that you got to play by certain rules. He just wants to do it his way. So if he wants to do it his way, we'll do it his way. It's not going to turn out real well. So what do you wish for me to do, Ms. Ford?
I'm asking that we set this for a preliminary examination, that you hear from the prosecutor and my client. Understand that I am really putting forth a top effort, and along with fighting, I actually have skill. So I hope that he understands that.
Well, he also needs to understand that there's going to be a motion for them to proceed by forfeiture, I'm presuming, and that's going to make your case whatever it is. And I know your counsel will be ready to go forward. I know the prosecutor will be ready to go forward. But you understand that, Mr. Abs?
I understand everything.
Okay. Then let's set.
In case so she does
Right.
not have discovery.
Correct. So
Just to the courts.
He has discovery on the first one.
on the first case, but not on the
Yes.
second case.
Correct.
How many, there were phone calls, so how many phone calls are we talking about? Because he's gonna have to see all of that, go through it
Okay.
all, so I wanna make sure he has time, so we're not hearing a complaint about that.
As long as possible, within reason.
Yes.
It has to be reasonable.
You never explained that when I asked you what they going on without the victim.
Oh, excuse me. Let me put this on the record. I did explain that I guess it's hard to understand the various exceptions to hearsay and how in certain instances they can go forward without the victim. I was trying to explain, and then the people gave me a case I haven't read, but I was trying to give him the site People versus Only 327 Mishap 319. Will the court please explain to my clients certain instances where they can go forward without the victim? Excited under its mental state.
There are exceptions to the hearsay rule. Given that this is a domestic violence case, there's a statute which would apply, which would allow them to proceed with police testimony. Also, and I don't know if this is the people's intent, they would file a motion to proceed by forfeiture, meaning that because of, a simple way of putting this, because of your wrongdoing, the alleged victim is not present. So the people would, in that instance, not be punished by what is your behavior, or at least allegedly your behavior, Mr. Epps, and so would be allowed to proceed. That's kind of a nutshell version. I mean, there are a little bit more technicalities to it, but I think that
One of the technicalities would be MCL 768.27C, and as I indicated, that case, People versus Only 327 Mishap 319, and the various exceptions to the hearsay rule. That might be excited utterance, present sense impression, mental state of mind.
yeah, I mean, it's all
other.
of that kind of thing.
Do I got a right to cross-examine my accuser?
You know what? Here's the thing, sir. That if you're talking about the right to confrontation, there's a statute particularly on point where that may be forfeited because of what is alleged to be your behavior. That was the last thing that I brought up.
What do you mean by that, sir?
I am not here to give a law school class, although I could. I'm not, I know, but I'm just saying that is very technical. That's why you have an attorney.
But I couldn't explain it anymore, and that's why I brought it up.
You just broke down law school for her. How am I different?
I didn't break down law school.
Okay, I'll tell you.
He asked the
We
question.
have told you.
All
right, well, I'm done. I'm going to set it for exam.
I'm going to go to the jail today, so I will. I'll tell you.
Preliminary examination in this matter, because
Yes.
people may have a motion. I'll set it for September 17th, 2020.
Okay, just one moment, please. Just. Yeah, don't turn your back on it, please.
September 17th, 2024,
Yeah, but he might be if you like.
9 a.m. That's before me.
Thank you.
When?
September 17th at 9 a.m. Oh, wait a minute, excuse me.
Why so long?
That's
3 weeks.
Yeah, September 17th, I can do that, but not the 8th, because that's the judge's calendar, and I'm going to defer the professional. There are some parameters, and you are not being, oh, that's the new thing in the jail I'm learning, that I'm being.
And I would anticipate the people's motion, so we'll try to hear that.
It's the new buzzword in this world, and everything is a violation of that.
Of what?
Speedy trial. That is the new buzzword in the.
That has.
Can I ask a question? What is about what's going on in the jail? Speedy. None of this particular about my case.
You just said you had a right to
like
speedy
this.
trial.
I didn't say. I asked why so long. I didn't say nothing
It's
about.
not a violation of speedy
I asked
trial.
why so long. I didn't say nothing about no speedy trial. Like Judge Simpson, this is where we having a conflict at, sir. I'm asking about my case, and it's everything other than the case. I don't want to talk about nothing but this case.
Okay, but Mr. Epps, hold on, slow down. You have two things now, which have, hold on. You asked me a question, but you're operating off of a premise that isn't gonna work. So here's the thing, you had the one case come up. We then had the hearing, there were allegations made, and this is where the complication comes in. There are allegations that are then made that there is phone contact and other communication. I don't know for sure. The allegations have been made. There's evidence of the phone calls. So that's where we are. What the problem then that happens is that leads to additional charges, which then not only is there now this additional felony, that clearly will have an impact upon what the first case that you came. That's what counsel's trying to get through. She's got to get that information. That then leads to other things.
Okay, I understand that. She's not explaining that, sir. That was simple things to understand.
I accept.
Okay.
We're good.
I can't get in between every counsel and attorney and defendant.
Thank you.
And I'm not trying to do that. I'm just trying to explain the process, and I've got to, Mr. F, I've got to be fair to both sides. So I got to have it worked out. You would have had an exam before now, had this not come up. Okay, so that's the reason for the stretch out in time.
Okay.
Also, the other thing, so that you just understand, it's not anybody trying to delay anything. Because of the allegations that come with that, and sort of this complicated thing, I won't say it's complicated, but it's a thing where they're going to proceed, presumably, and I don't know, they know this for sure, without the witness. Your counsel has to try to do some things. I've got to give her time to do that for your protection.
Okay.
So it's not trying to stretch anything out. I'm just trying to make sure everybody has an opportunity to do what it is they need to do. It's really as simple as that.
Thank you.
Can I say one more thing, sir? Yeah, my last court hearing that I will be able to get a hold to her when y'all took my phone.
Excuse me?
At my last court hearing, y'all took my phone. Y'all told me I'll be able to get a hold to her. I'm not able to get a hold to her.
You should be able to call your attorney.
We've talked,
I'm not able to get a hold to you.
I don't.
but we talked.
That
Somebody else now.
Oh, he's saying he had to go in the three-way, but we talked.
I'm not able to call her, sir.
you should be able to contact your attorney.
I'm not able to, sir.
Well, I can. Did somebody at the jail make sure that that can happen? Ms. Ford, check into that if you.
All right.
I'm
We are
done
today.
here, folks. Bond continue.
All right, so thank you for tuning into this case. Like I said, I always say all the time, defense attorneys, especially public defenders, they get a bad rap. They have so many cases on their dockets of people who do crime but don't have the money for the crimes that they commit. I would say this. If you cheat on your spouse, whether you male or female, have your first month and last month rent when you get put out. When you do crimes, have money in the bank to say, okay, my bail is going to be $2,000. They're going to probably want a cash bond, or even if they want whatever bond, maybe the bond straight up, and they don't want a percentage, they want the whole thing. Have the money in the bank. Don't become a career criminal and you don't have no money in the bank. And guess what? Now people got to do, they got to sell catfish nuggets and sell the good cornbread and the good muffins, the good oxtails, do the fish fry, everything else just to get you out of jail because you want to be a career criminal. Stop asking people to put money on your books if you want to be a career criminal. If you want to keep doing dumb mistakes over and over, stop penalizing the people that's trying to make it every day. Because you're being exploited in jail and things like that, right? I would say this. The way you spoke to this lady, Judge Simpson had to put you in your place, sir. You don't have to be in jail. You could be a law-abiding person as well. Everybody is one mistake away from being in jail. Yes, indeed. Everybody is one mistake away. But don't make these mistakes on purpose. Don't do it on purpose and then get mad because somebody ain't working faster because you can't even get out of jail, even if you get the first one dismissed, because you got 2 charges of the same crime or similar crimes. But nonetheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we'll be coming to you with more videos in the future. And once again, we will see you